wrong.
No, you weren't. It was me.
Doesn't take long for me to forget how this works. As we did yesterday.
Yeah. All right, thank you.
Well, good morning, everyone. This is John Neerman, and it's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Friday, September 25th, 2020. The time is 9:30 a.m., and I'll begin with a roll call. Commissioner Lindley, good morning.
Good morning.
And Commissioner Ginecka, good morning to you.
Good morning.
So our commissioners are all present, and how about our general counsel? Ms. Smith, are you there? Ms. Smith, you might check your microphone to see if it's muted. While we're waiting for Ms. Smith, let's check in with our public interest counsel. Vic, are you there?
I'm here. Good morning.
Good morning. And Ms. Smith, have you been able to join us yet?
Yes, I'm here.
Okay, good morning.
Good morning.
So I'd like to remind folks to keep their phones on mute when they're not speaking. I'd also like to remind anyone who is here only to listen that they can watch the meeting online, and that link is available on the agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits. Registration closed at 9:30, but if you would like to address the commission on a particular item, please email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to comment on, and we will do our best to accommodate that request. For those making presentations, please wait to begin your presentation until I or our general counsel have asked you to begin speaking, and please check to make sure that your line is unmuted before you do begin speaking. With that, I'd like to thank everyone for being present. And Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of Ingram Concrete LLC for air quality permit number 152417L001. The applicant should go first, followed by the protestant, the ED, and then OPIC. By letter dated September 4th, 2020, the parties were provided the following oral argument time limits. Applicant, 10 minutes. Protestants, 10 minutes collectively. The ED, 5 minutes. And OPIC, 5 minutes. The applicant may save some time for rebuttal as it bears the burden of proof on the application.
Thank you, and I'll ask the applicant to go ahead and proceed, and please identify yourself for the record, and the floor is yours.
Thank you, and good morning, Chairman Neerman, Commissioners Lindley and Ginecka, and General Counsel Smith. My name is Patrick Leahy. I'm with the law firm of Baker Botts. Along with my colleague, Derek McDonald, it is my honor to represent the applicant, Ingram Concrete, today in this permitting matter. Ingram seeks an air quality permit for a new rock crusher to be located at its existing washed sand and gravel plant at the M&W Ranch in Somerville County, Texas. This would be a small rock crusher that, if installed, would emit an exceedingly small amount of particulate matter, 2.04 tons per year, which includes 0.90 tons per year of PM10 and 0.17 tons per year of PM2.5. Ingram conducted a thorough air quality analysis based on TCEQ rules and guidance that demonstrated that the rock crusher's emissions will be protective of human health and the environment, including but not limited to that of the parties named as protestants in this matter. On each of the 7 issues referred by the commissioners, the protestants failed to present evidence that in this Senate Bill 709 proceeding rebuts the presumption created by the admission of the administrative record. Rather, the evidence offered both by the executive director's staff and the applicant Ingram in support of the permit demonstrated that Ingram has met its burden on all issues referred by the commissioners just last fall. The administrative law judges, the executive director, and the Office of Public Interest Counsel all agree and support the issuance of the permit as drafted. The administrative law judges, having heard the evidence, have issued a thorough and well-reasoned proposal for decision, recommending issuance of the permit as drafted. That recommendation and the judges' proposed findings of fact and conclusions of law are exactly right. Two of the protestants filed exceptions on one and only one issue in this matter, whether Ingram complied with the TCEQ's signposting requirements. The administrative law judges reviewed those exceptions and rejected them, noting that, and I'm quoting here, the substance of these arguments were presented at the hearing and in closing arguments and were considered by the ALJs when drafting the proposal for decision. That proposal for decision correctly found that Ingram complied with the mandatory requirements for this facility. We therefore ask that you issue a final order adopting the findings of fact and conclusions of law as amended by the administrative law judges in their letter dated September 15, 2020, adopting the executive director's response to comments in whole and issuing this permit as drafted. Thank you for your time. I'll reserve the remainder of my time for rebuttal, and I welcome any questions.
Thank you, Mr. Leahy. I have none. Colleagues, any questions? Commissioner Lindley
No, thank you.
and Commissioner Janeka?
Thank you. No.
Thanks. All right, well, let's hear next from the executive director, please.
Good morning. Can you hear me? I'm just testing my audio.
You sound great. Thank you.
Great, thank you. We had some issues this morning. Sorry. So good morning to General Counsel, Commissioners, and Public Interest Counsel. I'm Betsy Peticolis with the Environmental Law Division on behalf of the Executive Director. And with me on the line is Amy Browning, also with the Environmental Law Division, and Joel Stanford with the Air Permits Division. The Executive Director respectfully recommends that the Commission adopt the ALJ's proposal for decision with the ED's proposed changes as recommended in the Administrative Law Judge's September 15th, 2020 letter to the Commission. Thank you, and we're available to answer any questions.
Thank you. I have none. Commissioner Lindley, any questions?
None, thank you.
And Commissioner Janeka, any questions for Ms. Peticolis?
No, thank you.
Thanks. All right, we'll hear next from the protestants, and please identify yourself for the record, and the floor is yours.
Chairman, Commissioners, my name is Peter Gregg, representing at the hearing two of the protestants, and I have the opportunity to represent the other protestants for purposes of this closing argument, which I appreciate. We do appreciate the opportunity to be before you this morning. This rock crushing operation and associated quarry are going to destroy one of my client's businesses. It's going to fundamentally alter the lives of the individual protestants to this matter, and it's going to substantially impact the city of Glen Rose. Ms. Tack, if you wouldn't mind putting up Exhibit P7, I would certainly appreciate it. As indicated in this exhibit, the applicant's operation takes up the entire oxbow in the Brazos River adjacent to the Tres Rios Resort, which resides just under the scale to the left on this orientation. It takes up the area of the Brazos River adjacent to the homes of some of the individual protestants. And it is directly adjacent to the city of Glen Rose, just to the west as oriented. Despite what was represented in their application, the applicant has acknowledged that the quarrying aspect of this operation will extend not just to the identified lease line on this exhibit, but inevitably well past those identified lease lines, further and potentially directly adjacent to the banks of the Brazos River, as you south and, as indicated, pushing up to the north. That portion of the river is the reason so many people come to Glen Rose, and it is the attraction for the patrons of the Tres Rios Resort. The applicant's operations are going to permanently impact the lives of everyone living in the area of this enormous swath of blasting, digging, hauling, crushing, and trucking. This is happening across the state of Texas. You are well aware of the controversies surrounding these applications and operations, particularly where companies are choosing to site these facilities near residents and recreational areas. You're also well aware of the legal and technical standards applicable to these operations, as you have addressed in the context of other applications. We have set out in our pleadings our position on those legal and technical standards and where we believe the application runs afoul of those standards, and therefore where the PFD is in error. This morning, I'm going to focus on the one issue that is so vital to the propriety of the TCEQ's permitting program, notice, the issue that you referred over to the examiners as issue number 5. At the very least, individuals that are going to be living, working, operating a business next to one of these operations should know it is coming and should be able to make a decision about whether to get involved. To be clear, that is what commission rules require. That is what due process requires, as set forth by the U.S. Supreme Court, as set forth by the Third Court of Appeals. The applicant must provide notice of its application to afford individuals who may be affected by the grant or denial of the permit a meaningful opportunity to voice their concerns and participate in the permitting process. Whether intentionally or otherwise, and I apologize, but we have our suspicions, the applicant in this case avoided that meaningful opportunity for individuals to voice their concerns and participate in the permitting process by ignoring the Commission's rules established to provide for adequate notice. For this argument, I'm focusing, as predicted by the Applicant's Counsel, on the sign placement requirements of 30 TAC 39604, which, to be clear, is only one of 2 mechanisms by which an individual could be provided notice of the potential impact on their lives from an impending operation. To be clear, we have equal concerns, as we have briefed, about the misrepresentation about the location operation, as I briefly mentioned in discussion of Protest Exhibit P7. Regarding the signposting, 3 points, all undisputed, demonstrate that Ingram failed to comply with Commissioner's sign placement requirements in conflict with the PFD. First, it is undisputed that the specific sign placement requirements at issue, 39604C, are mandatory, not directory. As we analyzed in detail in our exceptions, that provision requires strict compliance with its requirements. Second, it is undisputed that Ingram's sign placement did not meet the specific requirements of that rule. The sign was not 10 feet from a property line. It was hundreds of feet from a property line. It was not paralleling a public road. It was not visible from a parallel road. Third, and critically, it is undisputed that Ingram did not seek or obtain a variance from those requirements as the rule allows and provides for and requires. Why did Ingram place the sign where it did? As Ingram represented, I had to post it as close to the property as it could be posted where it could still be seen by the public. Asked if that was a singular factor that they considered in determining where to post that sign, the answer, yes. With that, Ingram's consultants simply checked the application box that they had satisfied that requirement. The PFD ignores Ingram's failure to satisfy even one of the 3 mandatory sign placement requirements under your rule. It ignores the specific remedies set out in the rules allowing for the variance. It instead finds that it was sufficient for Ingram to place its sign at, quote, the closest place to the proposed site that touched a public road. That is not what the rule requires. That is what the PFD erroneously said. By requiring Ingram only to put its signs, quote, close to the property and, quote, touching a public road, the proposal for decision disregards the plain language of 604C, and it guts the specific requirements the Commission imposes on applicants under its own rules. And the PFD ignores the entire purpose of the provision of that same rule, providing for and requiring the variance mechanism under that rule. Ms. Tack, if you wouldn't mind putting up Exhibit P16C, I'd appreciate it. Their violation of 604 and their failure to obtain the required variance, their decision to make their own unilateral decision about where to place that sign, had substantial consequence. The applicant placed its sign at the end of a dead-end street at the red dot on the north of this P16C, which I hope you're able to see, where exactly two people would reasonably see it. Two people live on that dead-end street. Ralph Isham, who owns one of the two houses on the street, he saw it. The ALJ notes that Mr. Isham is the only person who's identified as having seen it. And the owner of the other house on that street, the owner of the property where the red dot is, the dead end of that street, is the person who is leasing that enormous piece of property to Ingram. Those are the two individuals that would ever see that sign. There are over 3,000 people in this area. Ingram placed their sign without TCEQ consent in a place where exactly two people would come across it. Referred issue number 5 asks whether the applicant substantially complied with TCEQ's public notice requirements. The applicant did not. The PFD is in error on that point. You know the applicable standard well, that this agency may vacate or modify a PFD if the agency determines that the ALJ did not properly apply or interpret applicable law or agency rules. There is no question the ALJ failed to properly apply or interpret applicable law in this instance. With substantial detriment to the interested individual that law is in place to protect. It is impossible to know how many individuals were denied the opportunity to participate in the hearing process based on the applicant's sidestepping of that rule. We cannot know. That is why initial compliance with the rule is so critical and legally required as a matter of law. This is a facility that is going to be harmful to the individuals in the community. And to be clear, it is a facility that is, and will emit substantial volumes of nuisance dust over the fence line, as the evidence establishes. The fact that individuals were denied the opportunity to participate and assert their position on this application based on the violation of the Commission's regulatory requirements requires that this application be denied. Again, thank you very much for your time and consideration on this matter.
Thank you, Mr. Gregg. Let's hear next from, or let me pause there and see if my colleagues have any questions. Commissioner Lindley? No. Commissioner Ginecca? Okay, hearing none, let's hear from the Office of Public Interest Counsel. You might double check your microphone.
Yes, thank you, Chairman, and good morning. Chairman and Commissioners, General Counsel, and the Executive Directors, Attorneys, and staff. I'm Sheldon Wayne for the Office of Public Interest Counsel. And after consideration of the evidence and the argument presented in this matter, OPIC agrees with the administrative law judges that Ingram has made the required showings that the facility will meet applicable best available control technology requirements. Its emissions will not exceed the national ambient air quality standards. Its air dispersion modeling was properly conducted. The draft permit contains adequate record keeping and monitoring requirements and adequate conditions to protect against nuisance dust. TCEQ's public notice requirements were substantially met, and the permitted operating hours are protective of human health and safety, as is the draft permit itself. For these reasons, OPIC recommends adoption of the proposal for decision as modified by sustaining the executive director's exceptions and issuance of the draft permit. Thank you, and I'm available for any questions.
Thank you. Mr. Wayne, I did actually have a question about the sign posting requirements, and you noted what your conclusions were about the public notice requirements having been satisfied. I was wondering if you could offer any more detail or substance to your analysis about the sign itself, why or how it did comply with the requirements.
Absolutely, Chairman. The sign, this particular piece of property, the evidence showed that there was only one area where a public road actually touched the property, and that area was where the road actually went became like a driveway of the property, for lack of a better term. It was at that intersection, kind of where the public road became the driveway, right at that gate, that the sign was posted, and that the ALJs found that the sign was posted in the only place where the property actually touched a public road. As far as the quarrying operation and where the quarrying operation could extend to, I know that's something the protestants mentioned just now. The ALJs concluded that the quarrying operation wasn't a part of this proceeding itself. This proceeding was only about the rock crusher, and because of that, it's not really at issue what the entire lease hold could actually expand to become or actually be used for, as long as that use was for the mining and quarrying operation and not for the rock crusher itself. And so the ALJs concluded that the sign posting requirements were substantially complied with, and because the sign was posted at the only place where the property touched a public road, that there was, I may be overstating this slightly, but that there was no other place for a sign to be posted, and so no variance was required for that.
Okay, thank you, Mr. Wayne. Commissioner Lindley, any additional questions for OPIC?
No, thank you for those comments.
Yeah, absolutely.
Commissioner Ginecca.
No questions for me. Thank you.
Okay.
All right, thank you, Commissioners.
Thank you. Let's go back to the applicant, Mr. Leahy. I think you may have reserved a little bit of time for rebuttal.
I have, Chairman, and I appreciate the opportunity to give that rebuttal. I just want to remind the Chairman and the Commissioners that the issue here is issue 5 of the 7 referred by the Commissioners last fall. It's whether the applicant substantially complied with TCEQ's public notice requirements for air permit applications to maintain jurisdiction to decide the application. The arguments that you heard counsel for the protestants make today are the same arguments that they made during the hearing, the same arguments they made on the exceptions. And the administrative law judges who heard quite a bit of testimony and took quite a bit of evidence on these issues concluded the same way both times, which was that Ingram had met its burden on this issue to show that it had substantially complied with the public notice requirements to maintain jurisdiction to decide the application. Their decision was correct. Ingram posted its signs at the only place where the ranch meets a road. The ranch here is surrounded on all sides by either the Brazos River or private land. That public road, it runs right into the ranch's entrance gate. If anybody were looking for this ranch, that's the road they'd drive down. There was testimony that from other protestants saying they'd seen the sign. The road itself runs right by the property of a couple of the protestants in this matter. The signs were posted on Facebook. There was a lot of evidence and testimony taken on this issue, and the administrative law judges found the same way both times. There should be no question here about whether there was adequate notice to the public of these proceedings. Over 30 people requested a hearing in this matter. As to the law itself, I just want to be clear about what that law is. It's Texas Health and Safety Code 382.056C, which says that at the site of a facility, the applicant shall place a sign declaring the filing of the application for a permit. As to where that sign is to be placed, the Clean Air Act is actually silent. TCEQ rules require that the signs be, and I'm quoting here, visible from the street. And they also direct that 1 to 3 signs be required along any property line paralleling a public highway, street, or road, and specifically be located within 10 feet of every property line paralleling a public highway, street, or road. That is to say, if a piece of property has a street running by it, there should be a certain number of signs along that street. Here, there's no such street. There's merely the point. And that point is where Ingram posted its signs. Even assuming, arguendo, that the rules required Ingram to post its signs in a different way, this is not a jurisdictional defect. And the notion that this entire proceeding should be thrown out on those grounds, I think, is simply wrong. So honestly, commissioners, there simply isn't that much more to be said about it. There is one place where any public road comes anywhere near this ranch. That one place is where Ingram posted its public notice signs. Those signs were seen by protestants in this proceeding. Those signs were made public, well distributed, and caused over 30 people to request a contested case hearing in this matter. The ALJs took evidence on this very issue, and they found ultimately that Ingram had complied with the requirements. As to the question of a variance, it's our position that no variance was needed. We complied with the law as written. Where a public street met this ranch is where the signs were posted. There was no public road running along the ranch to require additional signs. Anyone looking for information about this ranch or the ranch itself would have driven down this road, County Road 401, which again ran past the homes of some of the protestants to this matter. So with that, commissioners, I would respectfully request again that you adopt the conclusions of law, findings of fact in this matter, that you adopt the response to comments of the executive director, and that you issue this permit as drafted. And I'll take any questions you may have.
Thank you, Mr. Leahy. I have none. Commissioner Lindley, any questions or comments at this point?
No, thank you.
Commissioner Ginecka?
I was going to ask about the post on Facebook, and I think you pointed that out, and I appreciate that aspect of it as well. Mr. Leahy, I'm just curious, was that, can you imagine, were there any responses to that post on the Facebook or on the online platform?
Thank you for the question, Commissioner Ginecka. I did not see the post myself. The evidence in the record shows that the post was posted by a group that was opposing the issuance of this permit. So
good to know.
It was not merely posted by anyone, but specifically by the people who perhaps had a great deal of interest in joining these proceedings.
Understood. Thank you. No other questions for me.
Thank you. Well, colleagues, I certainly appreciate Mr. Gregg's arguments about the impact or potential impact of this facility on the community, and I believe him when he says that it's going to alter lives of the neighbors, and particularly in the neighboring resort. Our exercise here is to handle issues that are within our jurisdiction on the law, and what's teed up in front of us in this proposal for decision, multiple issues, but it seems that the focal issue is the public notice requirements, and specifically the sign posting requirements. I don't find any reason in the record to upset the ALJ's analysis on this point. It's further supported by OPIC's analysis. And so accordingly, I'm going to recommend that we adopt the ALJ's proposed order as modified by their reply to the executive director's exceptions, and that we grant the permit. That's my view of it. Commissioner Lindley, what are your thoughts?
I'm in agreement. I think that the administrative law judges did their job pretty well on this. I'm willing to adopt the PFD, what's before us today.
Commissioner Ginecka?
I reached the same conclusions. I'm comfortable proceeding today as well.
I'll entertain a motion.
I move that we adopt the ALJ proposed order as modified by the ALJ's letter dated September 15th, 2020, that we grant the application of Ingram Concrete LLC for new air quality permit number 152417L001 and adopt the ED's response to comments.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Ginecka?
Aye.
I also vote aye. Motion carries. Ms. Smith, please call the next item.
Item number 2 is the application by Epic Piping LLC for new air quality permit number 154774. The parties have been notified that the commissioners will not take oral argument but may ask questions.
Thank you. And for the benefit of those who are not familiar with our process, we begin our analysis of requests for contested case hearings by determining whether the requesters have met both the procedural and substantive requirements to be entitled to a contested case. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. Colleagues, in this case, we have 3 requesters, but each of them lives more than 3 miles from the site at issue. They therefore lack the proximity to establish an interest that is different from the general public. So on this item, colleagues, I think it's pretty clear that we're compelled to deny these requests. Commissioner Lindley, how did you come out?
I'm in agreement. I came down the same way on denying them.
And Commissioner Ginecka?
Likewise, came to the same conclusion.
I'll entertain a motion.
I move that we deny all hearing requests, grant the new air quality permit number 154774 to Epic Piping LLC, and adopt the executive director's response to comment.
A second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Ginecka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next items.
That takes us to the enforcement docket, which is items 3 through 21, and the executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Brian Sinclair of the Enforcement Division, and with me today are Megan Hamilton, also of the Enforcement Division, and Charmaine Backens of the Litigation Division, representing the Executive Director. Pending before you are items 3 through 21. The total assessed administrative penalties are $473,689, with $79,181 deferred, $145,232 applied towards supplemental environmental projects, and $249,276 to general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you. I have none. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Ginecka?
None, thanks.
Thank you. Ms. Smith, I understand we have at least one person signed in to speak on one of the enforcement matters.
That's correct. On item 18, Ms. Rosalind Caesar has signed in. And to allow enough time for all those who wish to be heard during the meeting, the Commission will limit these initial comments for each speaker to 3 minutes and extend that time if there needs to be further discussion with the speaker.
Okay, thank you. Well, good morning, Ms. Caesar. Thank you for being part of this meeting this morning, and make sure that you're microphone is turned on, and then the floor is yours.
Good morning, Commissioner. Good morning, Chairman and Commissioners. Thank you for giving me the opportunity to speak. Can you hear me?
Yeah, you sound great. Thank you.
Great. Thank you so much. My name is Rosalind Caesar, and I'm a homeowner and a precinct chair within Harris County Mud 304 District. I am coming to you as a consumer who drinks the water, and my family also consumes this water. I'm extremely concerned about the quality of this water that we are drinking today. I feel as though the mud in TCQ does not value my dollar as I do. At this point, both the mud and the TCQ has let me and my family down. I'm here today to speak on the agreed order issued by the TCQ to Harris County Mud 304. The violations are extremely concerning, which leads me to the point here. The lawmakers who create the rules, but TCQ does not enforce the rules. They are just simply suggestions. So the board has been aware of the issues for years now, which we are speaking of today, but there is no accountability, no oversight from TCQ. One reason why TCQ exists today. So moving forward, I expect a complete oversight, accountability, and most importantly, follow-up from this TCQ. Imagine this, turning your faucet on, and every time you turn it on, it's brown water. It's not clean water, it's brown water. So we tell the board this, and they tell the taxpayers to keep running the water until you get clean water. That's not clean quality water. So in closing, I'm asking the TCQ for more oversight, more follow-up, and more accountability from this commission. We just asking for simple, clean, quality water, not brown water. Thank you for your time.
Thank you, Ms. Caesar. Appreciate you being part of the meeting and sharing your concerns with us. The commissioners, I think, all share your concerns about making sure that all of our communities have clean drinking water in Texas, and appreciate your comments. Colleagues, any additional thoughts on the points that Ms. Caesar raised? Commissioner Lindley?
No, appreciate you calling in, Ms. Caesar.
Commissioner Ginecka?
I'm very curious to have a little more discussion and get a better understanding of it, but I don't know that I don't think that's something that Mrs. Caesar is prepared today. You mentioned that it's an instance where lawmakers create the rules, but TCQ doesn't enforce them. And I'm just curious to hear from you which specific rules you have, in your opinion, we're not enforcing the way that lawmakers have intended. So I'd love to have a little more discussion in terms of getting a better understanding of that. And that might be something that my senior advisor needs to follow up with you on. I don't want to put you on the spot and ask what we aren't doing, but I'm very sensitive to that suggestion, and I would love to follow it down. But thank you for taking the time to provide comments today.
Thank you so much.
So, Ms. Caesar, let me propose this. If you have any additional thoughts that you want to share at this point in response to Commissioner Ginecka's interests, I'd invite you to share those now. Otherwise, it sounds like he's going to make arrangements to reach out to you or to make some contact with you separate and apart from today's agenda. So is there anything else you'd like to share with the commission at this point?
Well, I have personally reached out to you, Chairman, but my conversation gets rerouted throughout the agency. And simple about clean drinking water, because this current board does not see that we need clean drinking water, which is part of the mission statement with the agency, right? And so that's part of the issue why we're here today, because, again, you guys agreed to the order with the board. So that's one reason why I'm here, and I will follow up with the commissioner on this. And, again, with the follow-up, because these violations have been sitting for years. And so I am excited about following up with the commissioner about this, because, again, if it's happening to us, it's probably more likely happening to other people. And I have reached out to our lawmakers about this, and they have helped us so far, and that's how we got here today. So I don't know if that answers your question, but we should be able to turn our faucets on and not have brown water. And Region 12 did somewhat of a work, but again, it comes back to the agency just basically doing the things they should do and making sure that, you know, everyone in Harris County Mud 304 gets clean drinking water, and we do not have that as of today.
Okay. Thank you again, Ms. Caesar. You know, clean drinking water is one of the most important, if not the most important thing that this agency does, because it does have such immediate impacts potentially to public health. I wanted to respond to your reaching out to my office and explain that the commissioners are prohibited from talking with people about certain items. It's an ethical rule. It's called the ex parte prohibition, and just simply what that means is that parties to a matter that could come before the commission, like an enforcement matter, can't speak directly to the commission. It has to go through a formal process, and the reason behind that is to give both sides an opportunity to present their cases to the commission at the same time. So we're hobbled a little bit, the commissioners are, in what we can talk about if it relates to an enforcement action or a permit. That those are both contested items, and we can't have conversations about those specific things. We can have broader conversations about issues, including what color your water is, if they don't implicate a contested case, enforcement action. But anyway, that's a limitation that applies to the commissioners. But there are a number of people within the agency, experts who are in a position to help answer your concerns, who aren't saddled with that ex parte prohibition. And so we'll make sure that those folks help coordinate any communication that you'll have with the agency. And finally, I just want to thank you again for being a voice for your community, because it's important for us to hear these issues, and that's what this forum is for. So thank you again. Colleagues, any closing thoughts on this item 18 before we move on?
No, thank you, Chairman, for helping reframe my question, put it back, and help explain it for our public here. Appreciate it.
Thank you. Commissioner Lindley?
No questions or comments. Thanks for explaining that. I always think that's you do a good job doing that, and I think it's helpful for everyone to hear.
Thank you. Let's hear next from OPIC.
Good morning, Vic McWhorter, Public Interest Counsel. For the record, first, I also would like to acknowledge Ms. Caesar for coming forward and sharing her concerns, and to the extent my office can play a role in helping facilitate communications with the right people at the agency and helping address the concerns Ms. Caesar's expressing, I'm happy to volunteer our services to facilitate those communications in any way we can. With respect to the other orders that are on the agenda today, all of the orders, actually items 3 through 21, my office reviewed these items, and we recommend approval of the orders as presented by the Executive Director.
Thank you, Mr. McWhorter. I've reviewed these items. I agree. I think we should move forward with approval of this docket. Commissioner Lindley, what are your thoughts?
I'm in agreement. I'm comfortable moving forward, adopting what's before us today.
And Commissioner Ginecka?
Likewise. That same for me.
I'll entertain a motion.
I move that we adopt items 3 through 21 as recommended today by the Executive Director.
I second.
Motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Ginecka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item 22 is consideration of the monthly enforcement report, and the Executive Director's staff is here to present the matter.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Brian Sinclair of the Enforcement Division, and with me are Charmaine Backens of the Litigation Division and Christy Mills-Durock of the Program Support and Environmental Assistance Division. We are here to present the monthly enforcement report for fiscal year 2020 through July. There were 1,387 effective administrative orders issued, and of those, 176 contained supplemental environmental projects. These orders assessed a total of $15,297,981 in penalties, with a payable amount of $8,791,874. $3,880,027 are to be paid towards supplemental environmental projects. 14,602 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,596 enforcement action referrals have been received. There are 1,441 pending administrative orders, with 155 cases on backlog, 207 cases that are pending at the Attorney General's office for representation in district court, and 16 judgments have been issued. 2,117 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2018, 2019, and 2020. We are available to answer any questions you may have.
Thank you, Mr. Sinclair. I have none. Commissioner Lindley, any questions?
No questions. Thank you, Brian.
Commissioner Ginecca?
Thanks. None for me.
And Ms. Smith, is there anyone signed in to speak on this item?
No one is signed in on this one.
All right. Well, let's hear from the Public Interest Counsel.
I appreciate the report. I don't have any questions.
Thank you, Mr. McWhorter. I want to share my observations and just sort of talk through my view of the report. And I'm paying some particular interest to it because there has been some interest about what effect the pandemic and our remote work posture has had on our enforcement activity. And so looking through the primary sets of charts about what our performance is currently as compared to the last two fiscal years, it looks like we're right on pace on the number of notices of violation issued. Similarly, for the enforcement action referrals, we're right on pace in line with where we've been the last 2 years on those. So no indication that that activity has dropped off at all, given our remote working posture. The number of effective orders issued, we are ahead of pace on that by what looks to me like hundreds, at least 100 effective orders, maybe roughly 10%, but we are certainly outperforming the last 2 years. Assessed penalties is a dramatic departure from the prior 2 fiscal years. We are millions of dollars ahead in the assessed penalties that we've imposed this fiscal year. So significantly outperforming the last 2 years. Similarly, for supplemental environmental projects, significantly outpacing the last 2 years. On backlog orders, we are also not as dramatically, but slightly outpacing the last 2 years, but that's not a good thing. Backlog orders are something we need to work on and catch up on, but you know, we have fewer backlogged orders currently than we had during a few months in 2018. So what we're experiencing now is certainly not out of line with recent history. Looking at the LBB metrics at the end of the backup material, we have already met, and this is for 11 of the 12 months out of the fiscal year, we've already met our goals for 2 of the 5 categories. We've exceeded the performance measures already for spill cleanup investigations and emission events investigations. the other three, we're not quite there yet. It's unclear that we will meet those requirements, although it appears that we're going to be close. And that experience of meeting some goals and missing others is typical of the last 2 years as well. So I'm not seeing in here any drop off really at all that might be correlated to the pandemic response. I think it looks like we're performing within normal parameters, or even outperforming last year's experience. So I did want to just take a few moments to recognize my view of the report. So with that, let me toss it over to my colleagues to see if they have any observations they'd like to share. Commissioner Lindley.
No, I really don't. I appreciate that, and I'm glad you brought it up. You know, working from home, didn't know what to think about it initially, and kudos to the staff. They've done, and every level of management, really, as far as I can tell, has done a pretty outstanding job of carrying forward the agency's business. And I don't think it would be fair to say that we have slacked off any or fallen behind the, numbers wise, and I just know how hard our employees work. And so I appreciate you doing kind of a deep dive and raising it. I think it's important for folks to hear that. Who knew that potentially working from home would potentially provide more areas in our agency to be more efficient, but I think that has somewhat happened. And anyway, so I'm glad you brought it up. That was a great overview.
Thank you, Commissioner Lindley. Commissioner Ginecka?
I don't have any other observations to make. I really appreciate your thoughts, Chairman, and I certainly agree. I think looking at the data as we're coming up on the end of our fiscal year, it really bears out that our enforcement process worked pretty well, weathered the abrupt shifts and organizational challenges we had over the last year. However, I'm still curious to see if and when and where and how in our process we do see impacts, because there was an effect on our ability to get out and interact with the public. I'm sure that will bear out. That legwork is necessary, and we're still finding innovative and really effective ways to continue to do it. But I'll be curious to see where as our agencies oversight and in the field compliance efforts make that handoff over to violations have occurred, enforcement needs to proceed. There may be some surprising impacts in the what's always, as you point out, Chairman, a mixed bag in terms of some years we hit some targets, some years we fall a little bit below targets. And I'll also just shamelessly repeat the soundbite I had before that performance measures are not, strictly speaking, and shouldn't always be seen as goals. This is how LBB tries to, and how the state tries to assess and keep a measure on its governmental agencies and entities. But I don't know that just because we haven't had enough enforcement actions in a year, our agency looks at that and says, oh, we need to go out and get more enforcement. I think we just start to say, okay, why was that, and explain it. So I appreciate the chance to remind the public and staff that that's the bars where we're working, but I'm really pleased with what I'm seeing as well, and I appreciate your thoughts. So thank you both.
Thank you, Commissioner Ginecka. And I agree with you that we need to, remain vigilant, stay on top of this, continue to understand the data that we're looking at, and continue to look for ways to, squeeze more efficiency out and improve our performance. And responding to Commissioner Lindley's comments, she was explicit in praising our staff. I was only implicit in my comments, but let me be explicit. I thank our outstanding staff for the great job that they're doing. So colleagues, no action is necessary on this item. So let's move on to the next one. Ms. Smith, if you'll call the next item, please.
Item 23 is the consideration of the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapters 35 and 291. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Brian Dickey with the Water Supply Division. With me on the line is Benjamin Worms with the Litigation Division. The proposed rulemaking would implement House Bill 3542 from the 86th Texas Legislature 2019 regular session to amend requirements related to appointment of a temporary manager to a water or sewer utility with fewer than 10,000 taps that has violated a final order of the Commission for the conditions listed in Texas Water Code Section 13.4132A3 and implement Senate Bill 700 from the 86th Texas Legislature 2019 regular session to allow the Commission or Executive Director to issue orders to ensure safe drinking water or environmental protection and emergency interconnections. The legislation also allows the Commission to delegate to the Executive Director to receive applications and issue emergency orders under Texas Water Code Sections 13.041H. Although not included in the backup material, the agency will be offering a virtual public hearing on this proposal on November 10th, 2020. The public hearing information will be included in the preamble/rule proposal and public hearing documents to be filed with the Secretary of State, Texas Register Division. Staff respectively recommends approval to propose the publication of and hearing on Chapter 35, Emergency and Temporary Orders and Permits, Temporary Suspensions or Amendments of Permit Conditions, and Chapter 291, Utility Regulations. Staff also respectively requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Ginecka?
None for me, thanks.
And Ms. Smith, I'm guessing no one has signed in to speak on this topic.
That's correct.
And OPIC?
OPIC recommends approval for publication of the proposed rulemaking to implement House Bill 3542 and Senate Bill 700 as recommended by the Executive Director.
Thank you. Colleagues, this rulemaking implements legislation that just further coordinates our activities with the Public Utility Commission in regulating public water and sewer utilities. I think we're ready to put this proposal out for comment, and that's my view. Commissioner Lindley, what do you think?
I'm in agreement, and I would support a motion.
Great. Commissioner Ginecka?
I will proceed with the motion. I would move we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code Chapters 35 and 291 as recommended by the Executive Director.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Ginecka, how do you vote?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next items.
The next items are item 24 and 25. They'll be taken up together. They are the consideration to withdraw from EPA's review the 1-hour ozone portion of the Beaumont-Port Arthur 1-hour ozone redesignation request and maintenance plan and 1997 8-hour ozone second 10-year maintenance plan SIP revision previously adopted by the Commission in 2019, and the El Paso redesignation request and maintenance plan state implementation plan revision for the 1-hour ozone NAAQS previously adopted by the Commission also in 2019. And the Executive Director's staff is here to present these items.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Kristen Jacobson with the Air Quality Division. With me are Terry Salem and John Minter with the Environmental Law Division. Additional staff are also available to answer questions as needed. For your consideration today are the Executive Director's request to withdraw from the United States Environmental Protection Agency's consideration 2 previously submitted revisions to the State Implementation Plan, or SIP. First is the 1-hour ozone portion of the Beaumont-Port Arthur redesignation request and maintenance plan for the 1-hour ozone standard, and second, 10-year maintenance plan for the 1997 8-hour ozone standard SIP revision, adopted by the Commission on January 30th, 2019. Second is the El Paso redesignation request and maintenance plan SIP revision for the 1-hour ozone national ambient air quality standard, adopted by the Commission on April 24th, 2019. Staff respectfully requests adoption of these SIP revision withdrawals and is available to answer any questions.
Thank you, Ms. Jacobson. I have none. Commissioner Lindley?
No questions, thank you.
Commissioner Ginecka?
None for me, thanks.
Thank you. And Ms. Smith, I'm guessing we don't have anybody signed in to speak on these items either.
Also correct, no one on these.
Thank you. Mr. McWhorter, what are your thoughts?
OPIC agrees with the executive director, and we support taking the action recommended by the executive director in removing these portions of the SIP revisions.
Thank you for that. And colleagues, it's pretty clear that EPA is not going to grant these requests. It's elected to take a different approach to the attainment of revoked standards. So I do think it makes sense to withdraw these requests. Commissioner Lindley, what do you think?
I'm in agreement.
Commissioner Ginecka?
Couldn't agree more.
I'll entertain a motion.
I'll attempt one. I move that we draw from submission to EPA the 1 hour ozone portion of the Beaumont Port Arthur redesignation request and maintenance plan for the 1997 8-hour ozone standard and second year maintenance plan adopted by the Commission on January 30th, 2019, as recommended by the Executive Director, and withdraw from submission to EPA the El Paso redesignation request and maintenance state implementation plan revision for the 1 hour ozone national ambient air quality standards adopted by the Commission on April 24th, 2019, as recommended by the Executive Director.
I second.
Motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Ginecka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next items.
The next items are for closed session, and the commission will meet in closed session via video conference or teleconference at, would you like 5 minutes, Chairman?
How's that work for y'all? All right, 5 minutes. Great, thank you.
At 10:36 as permitted by the Open Meetings Act, including Texas Government Code and the Governor's March 2020 Executive Order regarding the Open Meetings Act to take up and consider matters pursuant to items number 26 through 29 as posted and noticed.
Thank you, Ms. Smith. So colleagues, after we recess here in just a moment, we'll drop off this forum and join the executive session meeting. In the unlikely event that we take an action in executive session, we'll return here to announce that. Otherwise, I'll ask our general counsel to return to gavel us out. The time is 10:32 a.m. We stand in recess.
The Commission met via video conference for closed session from 10:36 a.m. until 11:43 a.m. on item numbers 26 and 27, as posted in notice pursuant to Texas Government Code Section 551.074 and the Governor's March 2020 Executive Order regarding the Open Meetings Act. No action was taken. The agenda stands adjourned, and the time is 11:46.